to introduce Heather Nancarrow. Heather is Chief Executive Officer of Australia's National Research Organisation for Women's Safety. She has held many leadership roles at both the state and national level, involving the development of policy on prevention of domestic, family and sexual violence. This includes work on the development and implementation of the Queensland Government's policy to stop violence against women, management of the Queensland Government's Domestic Violence Policy Unit, and membership of the National Partnerships Against Domestic Violence Task Force from 1998 to 2002. In 2002, Heather was appointed Foundation Director of the Queensland Centre for Domestic and Family Violence Research, a position she held until her recent appointment to the NCE. During that time, Heather was Deputy Chair of the National Council to Reduce Violence Against Women and the Children, which produced Time for Action, the blueprint for the Council of Australian Government's National Plan to Reduce Violence Against Women and their Children, 2010 to 2022. Today, Heather will be presenting on past, present, future reflections on Australian efforts to prevent violence against women. Can we please welcome Heather?
Thanks very much. Reasons to look back. First of all, I think we need to honour the work that's gone before. You know, there has been 40 years of effort to reduce violence against women and their children, violence against women in various ways, reduction of sexual violence, responding to sexual violence, responding to domestic and family violence. And that we need to honour that work and be able to build on it. So looking back also helps us find direction for the way ahead. And we need to acknowledge the milestone of achievements that have occurred over those 40 years. It's really easy to feel despondent, after this 40 years of effort, and yet we still have such high levels of violence against women in our communities. The Personal Safety Survey of 2012 shows that there's been virtually no reduction in intimate partner violence since the Personal Safety Survey was conducted in 2005. How can that be? You know, what's going on that we can have this level of violence and continuing violence? I'd like you to pause for a minute and think about the women that you love, the women in your families or your colleagues, people who are important to you. Think about all those women in your family, your friends' partners, and realise that 1 in 5 Australian women, 1 in 5 of them, has been sexually assaulted since the age of 15. 1 in 6 women are abused by a current or former intimate partner. 1 in 6, and more than half of those had children in their care at the time that they'd been abused. Overall rates of homicide are decreasing, except domestic homicide, which apparently remains static. Take a minute to think about the women who've been killed in domestic violence. Women, children and men who are killed as a result of domestic homicide. As I said, how can it be that we've put in 40 years of effort and we still have this incredible problem in our communities? Not only does it cause this devastating effect and the large number of women and children and men who are affected by this violence, but it also costs the Australian economy an estimated $13.6 billion per annum currently. And if we continue at the same rate of violence that we have against women as we do today, by 2022, that economic cost will increase to $15.6 billion per annum. So even if we're heartless enough not to care about the impacts of violence against women and their children, then we ought to be looking at what those costs are to the broader community. So what has been done and what do we need to do next? I'd like to take us on a bit of a journey, and I hope that as we go I can share some stories that help, I suppose, put this in context and help people understand where we've come from and where we need to be going, or how we've arrived at the position that we are now. I'm going to assume that many of you in this room don't know a lot about what happens in the domestic and family violence sector and the sexual assault sector. So I will draw on stories that some of you might be familiar with, but probably the majority won't be. I need to say that whilst not all of my work has been focused on domestic violence, some of it's been in the sexual assault area, but mainly in terms of policy development, most of my work has in fact been in the domestic violence area. So examples that I will draw on are likely to be more focused on domestic violence and sexual violence. Also, most of my work has been done in Queensland. I've only recently moved to Sydney to take up the position as CEO of this new research organisation that I'm going to talk about in a little while. So I've been in Sydney for 3 months. So again, my experience in Queensland will flavour the examples and the stories that I tell in particular, but I will try to look at the major developments across the entire country, or developments that happen in Queensland but that are equally relevant in other jurisdictions. Where I'll begin is the 1970s. Who remembers those? Some of you weren't born, I know. But really, not only in Australia but internationally, the violence against women movement, and particularly the movement against domestic violence or intimate partner violence, began with feminist activism in the 1970s. In Australia, it started really in earnest with a group of women in an inner city suburb squatting in a couple of abandoned buildings and creating the first Australian women's refuge called Elsie's. Among those women was Anne Summers, who many of you will know has been a very long and hard-working advocate and activist in the area of working to prevent violence against women. And she tells a story of how one of her colleagues, Diane Beaton, attended an ALP conference, a Labor Party conference, and collared Bill Hayden and insisted that he fund the women's shelters. So it was a few weeks later, Bill turned up at the women's shelter in Glebe and knocked on the door, and the women in the shelter chased him away, saying, "No men are allowed here, only women are allowed here." And then he explained who he was, and they invited him in, and that was resulted in the first funding of women's shelters in 1995. So Elsie started in 1994, 40 years ago, and the first funding started in 1995. At that time, and for the first at least 5 years or so, that was the only response in Australia to domestic violence. The only way that we were, as a society, able to support women and children affected by domestic violence was to ask them to leave the perpetrator. Can you imagine that you are in a family, there's violence, it's back in the 70s, it was very difficult to get any kind of support. Women with children had very little, if any, access to childcare. Being able to support themselves economically was extremely difficult when you had young children, if they'd been out of the workforce for a while. And some of these issues are still present today for women who are faced with a violent relationship and looking at what their options are for dealing with that. My first job in this area of prevention of violence against women was as the weekend worker at Windana Women's Shelter in Brisbane. Back in those days, women's shelters had 20 staff, 24 hours a day, 7 days a week, 365 days of the year. We also had a minibus, and part of my job was to drive that minibus and pick up women and kids from various places, sometimes at the family home, but often it was during the middle of the night at a phone box from where they'd called crisis care, which was the source of referral to the refuge. And so off we'd go, sometimes on our own, sometimes a couple of us if there were two workers on, but usually there wasn't on weekends and after hours. And often we did get support of police to come with us. But there became times when there were some police who would refuse to accompany us because unless there was a family court order that had recognised whose property it was, so it was very difficult to be able to get any way of supporting women unless they were prepared to leave and come to a refuge. There was just no other support, no services, no laws, nothing. So if the 70s were characterised by feminist activism and women's shelters, the 80s were really across Australia recognised by reforms in a wide range of areas. Every jurisdiction in that decade undertook a task force investigation. Task force investigations were set up by government to examine the extent of violence, domestic violence in particular, in their jurisdiction, and to make recommendations about how to respond. And again, it was feminist activism that led to the development of the task force investigations. And here I'd like to draw on, my experience in Queensland. I want to, at this point, and I'll come back to this a little bit later, I think as well. Queensland in the 1980s was governed by the Bjelke-Petersen government. It was the height of the Fitzgerald inquiry in the mid-1980s that investigated police corruption, and which then led to the jailing, in fact, of some police ministers for corruption. Sorry, not just police ministers, but ministers in general. It was a time of very conservative politics. It was a time of the Secret Service, or the special branch as they were known. So feminist activism was, I think, it's interesting when you look at Queensland as a case example of, or case study, that just how much was achieved in terms of feminist activism and responses to violence perpetrated on women by their intimate male partners. What was traditionally seen as a private realm, but here we were in Queensland during the Bjelke-Petersen era with the special branch, checking up on what radicals were doing and so on. But at the same time, we had incredible success. So when I was at Windana, a group of women lobbied for the establishment of other women's services, and particularly other feminist organisations such as Chisholm Women's Shelter and the Migrant Women's Emergency Support Service and the Domestic Violence Resource Centre. And the government funded all of those. Between 1984 and 1987, those three organisations were established in Brisbane. And that group then, or those groups of women, so the momentum built with the increasing number of services and the establishment of a domestic violence action group that then lobbied for the establishment of the Queensland Domestic Violence Task Force. So Queensland Task Force was set up in 1987, and it was among the last of the jurisdictions to do so in Australia. The New South Wales Task Force investigation had started in 1981. And it led to legislative reform and a range of other reforms, as did every other task force investigation. So in Queensland it was, and all of this legislation was civil domestic violence law. In Queensland it was the Domestic Violence Family Protection Act. That name has changed, but it's I think a subtle but very important framing of the problem. It was a problem that had to be dealt with because we needed to protect the family. Domestic Violence Family Protection Act. There was a lot of concern at the time about the incredible police powers that were given in the bill that was introduced in March 1989. And the Fitzgerald inquiry reported in June 1989. And because of the allegations and the disclosure through Four Corners, the Moonlight State, and Phil Dickey's articles in the Courier Mail about police corruption and about Fitzgerald's report in June 1989. There was a lot of concern about these incredible police powers in civil law. At the same time, there were feminist scholars arguing that civil law was trivialising, minimising domestic violence because it should have been dealt with in the criminal law. Why are we creating civil law for this when if you go and beat somebody up at the pub, you're going to be dealt with under criminal law, not some piece of civil domestic violence law? So there was a lot of debate. On the one hand, the feminist scholars were saying it's too weak. On the other hand, the civil libertarians are saying this domestic violence legislation is problematic because it's giving police unheard of powers under civil law. Police could enter premises without a warrant. Police could detain a person suspected of domestic violence for up to 4 hours without any charge. They needed to make an application for a protection order. Police could take that person into custody using any force or such force as they thought necessary, and with no other authority than that piece of legislation. So of course the civil libertarians were concerned about giving police, particularly at that time in Queensland, those very significant powers. And of course the making of a protection order, whilst it was a civil action, and charging a breach of an order is also under the civil law. a breach of a protection order is a criminal offence. It's a summary offence, but nevertheless it's a criminal offence. So we had these two pieces of, these two competing claims about the value of civil law. The Domestic Violence Task Force in Queensland and other jurisdictions, though, came down on the side of having civil law instead of criminal law because, in part, the criminal law had, in theory, been available to deal with domestic violence but had not been effective or not been applied. One of the reasons it hadn't been applied is because of the need to prove beyond reasonable doubt that the facts of the case and given the nature of domestic violence and the privacy in which that violence occurred and the reluctance of victims to speak about it, that the criminal law hadn't been successfully used or hadn't even really been thought of. And so the civil law, what the civil law also did in Queensland, I think this is quite unique to Queensland, under Queensland law, to apply an assault charge, the victim themselves has to make a complaint and request that assault charges be laid. So nobody else can do that on their behalf. The police can't do that without a complaint. And so the idea of the civil law was to be able to remove the onus of requesting intervention, police intervention, legal intervention, and put that onus on police. So police could make an application for a protection order without the consent of the victim, regardless of the wishes of the victim. And again, this was a controversial aspect of the legislation from a civil liberties perspective, and to some extent from a feminist perspective. There were certainly arguments about whether it was, understanding that because of the nature of the violence, we should remove the onus from the victim having to make a complaint against their partner, but then taking power away from women and giving that to police. So, there are all these kinds of debates. But nevertheless, we do have civil domestic violence laws, and at that time in all jurisdictions, and then a couple of the jurisdictions have moved to a predominant criminal response. So Tasmania, for example, now has a predominantly criminal justice response to family violence, which they call domestic violence, but with the civil law as a backup. And the other jurisdictions, such as Victoria, have employ a pro-arrest policy. So there's certainly over the years, although we started with a very predominantly civil law response, have moved more towards increasing the criminal response. The Queensland legislation and the task force was very clear that it was dealing with a particular kind of violence in families, and they were talking about the kind of violence that was patterned. It was a coercive control, although they didn't use those terms. It was violence that occurred in a context where there was an imbalance of power and where one partner, most often the woman, was living in fear of the other partner. That's the kind of violence that the task force set out to deal with this legislation. And they also said that it ought to be used in conjunction with the criminal law, not instead of the criminal law. I think, there obviously during the 80s, and as a result of those task force investigations, more than just civil legislation introduced. It also included awareness-raising campaigns, government policy and funding for a wider range of services. It wasn't really until the 1990s, though, that we saw a broader range of services being funded. So, again, in Queensland, regional domestic violence services that were providing counselling and support for women who could come to a service, or that there could be more outreach. So rather than having women only getting a service if they came to a women's shelter, there were now a wider range of services in the community, including free 1-800, I think they were 300 numbers at the time, but telephone numbers that women could call in from anywhere in the state and be able to get some support and access to other services in their local community via centralised phone numbers. There was also more law reform in the 1990s. So in addition to some amendments to legislation, the civil domestic violence laws, there was also the introduction of stalking laws. This was in Queensland again, and I'm sorry, I feel like I'm speaking too much about Queensland, but I did warn you that that's where most of my work has been done, and that's what I know best. But Stalking laws were introduced in Queensland, and it was the first jurisdiction to introduce, in Australia, to introduce stalking laws, and that occurred in 1992. That also came as a result of women's experiences, workers' experiences of working in refuge, where one of the workers at Windana, the coordinator of Windana Women's Shelter, Karen Struthers, she was the coordinator of Windana Women's Shelter, I was the coordinator of Chisholm, and there was a particular man whose partner was first at Windana, and he fronted up to the refuge with weapons and threatening to kill his partner and everybody there. So the refuge closed down, the women were distributed to other refuges. His partner came to Chisholm. He was able to, this is in 1987, so again before the civil domestic violence law. The only available law at the time for restraining orders was the Family Law Act, and it was limited to women who were married or women who had children in their care. But in this case, because they were married, we were able to seek a restraining order for her, but not for us. So her partner, Dave, followed us from the family court, and that began a pattern of his stalking us for many years, and well beyond the introduction of Queensland stalking legislation. The stalking legislation had some difficulties initially, and there were, have been amendments, and I was very pleased to hear from Assistant Commissioner Peter Martin. I'm not sure if Peter's here this morning. There he is. Peter was telling me that, because it seemed to me that the stalking legislation wasn't terribly effective because it was very difficult to prove. But however, with the technology and use of technology now for stalking, whilst that's introduced another mechanism for stalking women, it's also introduced a means of evidence so that the stalking laws actually are being used more than I was aware. So that's good to hear, because there are other reforms such as rape in marriage. Until 1989, it was not unlawful for men to rape their partners. Until that law was changed, until the criminal code was changed in 1989 in Queensland, it was still lawful for men to rape their wives. And so again, there was law reform there, but the ability to actually apply that law. And I don't know of any case where a woman has successfully charged her partner with marital rape. I'm not saying it hasn't happened, but I'm just not aware of that having happened. So I'm going to move on a little bit more quickly. I suppose, really want to give you a flavour of just how much effort's gone in and what kind of initiatives have happened. So in the 90s, as well as these, introduction of stalking laws, we had more task force investigations. So we had a task force on women in the criminal code that was about looking at what needed to be changed around rape law. And we had the Aboriginal and Torres Strait Islander Women's Task Force on Violence. And one of the things that was very interesting in that task force investigation, which coincidentally was at the same time as the task force on women in the criminal code, those two groups of women, one one exclusively Indigenous women and one predominantly non-Indigenous women, with the exception of one Aboriginal woman and one Torres Strait Islander woman out of a group of 19. Those two task force that reported to the same minister in 1999 made opposite recommendations about the utility of restorative justice as a response to violence against women. The Indigenous women were saying that given the overrepresentation of Indigenous men and women in the criminal justice system, and given the failure of the state to have protected Indigenous women, and because police intervention often resulted in more violence against Indigenous women, not less, that they needed to have an alternative response, a response that was more driven by and owned by their communities and operated in their communities, and held perpetrators of violence accountable to the community. So we talk a lot about perpetrator accountability, but we don't really know what that means or what it looks like for different groups of people. Aboriginal women are saying, particularly in remote communities in Queensland, have frequently said that, we have a magistrate that flies in once a month. The police and the magistrate fly in, they convene the domestic violence court, they make a protection order, and then they go away. It means nothing. Usually perpetrators don't turn up to a hearing. Applications are often made by police. They charge with breaches of protection orders, they plead guilty. So nothing in that process has any impact or relevance or meaning for them. They're frequently fined, unless it's a very serious assault, and sadly in some cases in Aboriginal communities it does mean that Indigenous men and women are more likely to be jailed than non-Indigenous men and women because of the nature of the violence that is occurring in the context in which that occurs. It's very dangerous, you know, the glassing and stabbing and so on that occurs. But Indigenous women have long struggled for different ways of responding to domestic violence, and the feminist community hasn't always been very good at hearing what it is that Indigenous women want, and why they want that, and why there needs to be a different response to that of the mainstream response. So we need to get better at listening and to different groups of women about what their circumstances are and what's going to work for them. I'm conscious I'm going to run out of time if I go into too much detail on any more of them, so I'm just going to pick out some of the highlights. I mentioned the awareness campaigns aimed at, I suppose Task Force Investigations thought that if we can raise awareness in the broader community about how terrible this violence is, what the impacts on women are and on children, and how prevalent it is, then the community will just get together and stop it. And so, for example, there was the Australia Says No campaign, which is a national campaign, television campaign that really focused on physical violence and sexual violence, that didn't really deal with the ongoing, coercive control, the pattern of behaviour that really characterises domestic violence. And there were in Queensland, again from the 1992, has held an annual domestic violence awareness campaign. So it started off as a week in 1992, and then it's now a month, and it occurs in May every year. And so it's governments and communities working together, but there isn't much of an evidence base for what that looks like or how it should be done. It's kind of, someone gets an idea and they get a committee together and, think about what the message might be and so on. The only evidence-based community education campaign that's occurred in Australia, to my knowledge, is the Freedom from Fear campaign from Western Australia, which was a social marketing strategy that was very much based in, it had a research base to identify what is the message that's going to talk to men who perpetrate violence about stopping that violence. And that research identified that men were more likely to engage with a campaign and get help if they understood the effect of their violence on their children. So they didn't care about what happened to their partners or how she might feel. They didn't care about what people in the community might think of them. What they cared about was the impact that the violence was having on their children and their relationship with the children. So in the 2000s, we saw more law reform. We'd had law reform in the 1990s on civil domestic violence law, but also family law, where we introduced the concept of the assumption of shared parental responsibility. In the 2000s, we had to fix some of the problems with that legislation. So, I think what I'm trying to do, I guess, in terms of emphasising the legislative reforms, we just seem to have more, every decade, reform, introduction of legislation, amendment to legislation, another piece of legislation that then conflicts with this piece of legislation. And, we've really invested a lot of time and effort into law as a response to domestic and family violence. We haven't done a lot in terms of law reform in the area of sexual violence. I mean, there has been some, and some would argue that the law on sexual violence isn't bad, it's about the implementation, and some would argue that is the case for domestic violence as well. Some of the challenges that we're facing or faced and continue to face throughout these decades is issues around gender, the idea that violence is, that there's also mutual violence, that men can be equally the victims of domestic violence in particular, and men are also equally victims of sexual violence. However, it's men who are perpetrating that violence. We know that in general, if you look at violence broadly, we know that men are at far greater risk of violence generally than are women. But men are at risk of other men's violence, mostly acquaintances and in public settings. Women are most at risk of men's violence too. It's men who are perpetrating the violence in the main. Women are, however, most at risk of violence in the home and perpetrated by their partners or another family member or somebody known well to them. So this idea of gender symmetry in relationships has been around for a very long time. In fact, since the 70s, with the work of Steinmetz and Gelles and I've forgotten his name. Judy, help me out. Anyway, the most famous of them, who's still presenting at the American Society of Criminology conferences about gender symmetry. So they wrote the book, The Violence in American Families, and which showed gender symmetry. They created the conflict tactics scale, which is a scale that basically measures violent acts without any reference to the context in which those violence acts occurs. And so it's just asking people to complete a survey, a telephone survey, asking about, have you ever used these tactics in responding to a conflict? So pushed, kicked, slapped, all of those things. So that kind of research has found gender symmetry. Other research, however, finds a great difference in terms of men's and women's levels of violence, and research that's drawing on the areas of justice data or health data, hospital data and so on, find that women are overwhelmingly victims of domestic violence and men the perpetrators. And it's about context, but regardless of the theorists who believe in gender symmetry and those who see that it's asymmetrical, with women being predominantly victims, all agree that it's predominantly women who are harmed, who suffer psychological and physical harms, more so than men in cases. And they also suffer more in terms of loss of autonomy and impact on their ability to conduct their lives autonomously because of the broader social structure in which women don't have the same access to resources and power as men do. So in the 2000s, and I've only sort of skimmed across some of the developments. I haven't talked much about the development of risk assessment tools and routine screening in hospitals, the domestic violence death review committees and processes and so on. But you're getting a sense, I think, of just the range of activities and the effort that's gone in over the last 40 years. And these are phenomenal achievements in a context in which there's not always been support for the efforts of those who are doing the work. There's been limited funding, there's competition for funding, there's been debates about which is the best way forward, there's been debates within the feminist community, there's been debates between the feminist community and the civil libertarians, there's been debates between Indigenous and non-Indigenous women and so on. So it's complex. One of the things that, whilst we've had a number of efforts over the years to bring together that effort and to look at, in a more systematic way and to look nationally at how we move forward nationally, it's only in recent times that we've really been able to come to grips with that. In the late 1990s, there was Partnerships Against Domestic Violence, for example, which was a national initiative under the Howard years that did have support from every state and territory, but very minimal resources, like something like $200,000 per annum for each jurisdiction to do some work, trying to find out what works best in responding to domestic violence in various contexts, and then sharing the results of those reports across the country. But it wasn't a particularly coherent plan or well thought through or an agreed plan. So in 2008, the federal government established the National Council to Reduce Violence Against Women and their Children, recognising that there's been all this effort, there's been incredible achievements along the way, but we really need to work better together to figure out how do we move forward in a more coherent way. So the Rudd government commissioned the National Council to Reduce Violence Against Women and their Children to come up with a plan to present to government as to how we might move forward. Kevin Rudd met with the council at its first meeting and said, if you can give me the evidence for a plan, I'll find the resources to implement it. So the council was given 6 months to come up with a national plan. The council took 9 months and presented Time for Action, which had 132 actions across 6 key outcome areas. Presented that to the federal government. There was an immediate response with commitments to establishing various things, but most critically a commitment to take the time for action to the to the Council of Australian Governments, where they would negotiate an agreement across all states and territories and the Commonwealth to a coherent, long-term plan and vision to reduce violence against women and their children. The national plan is a 12-year plan. I get very excited when I talk about the national plan, and I hope you will too, because this is the best opportunity ever in our country's history. It's the first time in our country's history that we've had the opportunity and the support of all governments across Australia, the Commonwealth, all states and all territories, to jointly commit to a 12-year plan to reduce violence against women and their children. So the plan started from 2010, so it's 2010 to 2022. It's to be implemented through a series of 4 three-year action plans. So the governments are currently at the stage of developing the second national action plan, and that's negotiated between all the states and territories. There's an agreement about this is the action plan, the plan of action, and it does provide states and territories some latitude to implement things differently, or to address their own priorities in their own jurisdictions, but within a coherent framework that is under the national plan and that's consistent with the current national action plan. And those national action plans were designed, or are meant to be designed, so that they're sequential, so that one builds upon the other, and we don't just have a 12-year plan and we get to the end of that plan and then look back, but there's an opportunity to consider at 3-year intervals what's been achieved in the last 3 years, what do we need to do next, how do we build on the gains that have been made. The national plan identifies 6 outcomes, 6 national outcomes. First, communities are safe and free from violence. Second, relationships are respectful. 3, Indigenous communities are strengthened, and this recognises the relationship between high levels of violence and structural disadvantage and structural inequality. 4, services meet the needs of women and their children. 5, responses are just, so we're talking about the justice system in particular there. And 6, perpetrators stop their violence and are held accountable. There's that word again, accountable. What does that mean? For some people it means punishment. I think for others it means men taking responsibility for their violence. But how do we do that? So one of the key elements of the time for action and subsequently the national plan was the need to build evidence. Because over the years, although we've had these incredible achievements in terms of initiatives and legislative reform and policy initiatives, we haven't been terribly good at building the evidence base for what we do and demonstrating to government that we ought to be doing more of this and perhaps not so much of that. Practitioners have a lot of practice wisdom, and there's a lot of knowledge there that can be harnessed to inform our work going forward, but we haven't been good at doing that. So the national plan, based on time for action, recognised the need to build evidence to support the implementation of the national plan to achieve these 6 outcomes. So a key element of the national plan, as recommended by Time for Action, the National Council to Reduce Violence Against Women and their Children, was the establishment of a National Centre of Excellence to reduce violence against women and their children. And the role of that National Centre of Excellence was to build the evidence to support the implementation of the plan. The National Centre of Excellence was recently renamed, and it's now Australia's National Research Organisation for Women's Safety. It's been in the establishment phase for about, more than a year now, so it took about a year to get the work done to establish the centre, and it's been launched. So I'm going to tell you a bit more about about NROS, so Australia's National Research Organisation for Women's Safety, NROS. So the strategic goals of NROS are to deliver high quality, innovative and relevant research, to ensure the effective dissemination and utilisation of research findings, so take up of the research findings, build, maintain and promote collaborative relationships with and between stakeholders. So the stakeholders are the governments, the research community and service providers or practitioners. They're the primary stakeholders of NROs. And the fourth goal is to be an efficient, effective and accountable organisation. So NROs has three core intersecting functions, which we have framed as knowledge production, knowledge translation and exchange, and leadership. The key task for ANROS has been to develop a national research agenda to reduce violence against women and their children. That work has been completed and it was launched along with ANROS on the 16th of May. And I'll talk a bit more about that in a moment. Its task is to undertake a program of new research under the National Research Agenda. So ANROS's own work will obviously be under the National Research Agenda and the priorities that it identifies for its organisation within that. But what's really important about the National Research Agenda is that it's the agenda for the whole of Australia. It's there to guide the undertaking of research directed towards reducing violence against women and their children for everyone, regardless of the source of funding. I will talk now briefly about how that National Research Agenda was developed. It wasn't, obviously there had to be a rigorous process about ensuring that the agenda, was an appropriate an agenda, and one that was informed by what we already know and where the gaps are in knowledge. So as it was called then, the National Centre of Excellence commissioned two pieces of work. One was a current state of knowledge in terms of statistical information on violence against women and their children, and the other was a gap analysis of the contemporary literature on violence against women in Australia. And then there were 127 written submissions to that, and then there were 6 roundtables around the country that all informed the development of the National Research Agenda. The task of NROS includes also facilitating collaborative links between policymakers, service providers and researchers, so they're our stakeholders, as I said. And most importantly, I think, if one function is more important than the other, it's about translating what research findings into information that can be grasped readily by policymakers and practitioners, so it's taken up. We have had a good record of research in the violence against women area, but it hasn't always been translated into practice or into policy. And what we want to do differently at ANROS is to build capacity in research and build relationships so that rather than having researchers in universities do a literature review and decide what they think is most critical in terms of filling gaps in knowledge, and then having completed their research, take their findings to government or to practitioners and say, I've done this research and here are some outcomes from it and you might be interested in implementing these. What we want to do is reverse that process and have researchers, practitioners and policymakers work together under the National Research Agenda to identify, and certainly for that which we'll be doing directly or funding research from ANROS, we certainly want those people to be coming to us with applications for research funds that demonstrate that they have collaborated, that they do recognise what the issues they're grappling with currently and how they're going to develop a research proposal or how they're going to undertake research to provide the evidence they need to inform their practice. So it's coming from the other way around, if you like. So I think just in terms of the National Research Agenda and the ANROS research program for 2014 and 2015, both of which were launched on the 16th of May, each of them are structured around the outcome areas of the national plan. So remembering that ANROS was established to develop evidence to support the implementation of the national plan. So we've identified for the National Research Agenda 4 strategic research themes. So it's experience and impacts. We still need to do quite a bit of theoretical and conceptual work before we can move into looking at some of the more practice-based interventions. The second is gender inequality and primary prevention, recognising again the structural inequality in terms of gender inequality and racial and other inequalities don't cause but contribute to domestic violence and sexual violence against women. The fourth strategic research theme is service responses and interventions, and the fifth is systems. So for the ANRO's research program, we've also identified a fifth strategic research theme, and that is about research to inform knowledge, translation and exchange. So that will help inform our work, but also others who are doing work in translating research findings into accessible formats that can be readily grasped by policymakers and practitioners. So I guess a core principle, as I mentioned, is collaboration, partnerships and capacity building. And we're inviting now, and as of the 16th of May, people to form consortiums or collaborations or however you like to frame it, but for researchers and others to get together and identify from our research priorities, which are on the ANRO's website, which is the W's, ANROWS, ANROWS.org.au, and you can see the information about our research program there, the range of priorities that are now available for open grant application. We're wanting people to make submission for grants in the open grant application process by the 11th of July. So, we can't do this work alone. We will be directly commissioning some projects, and we will be working with jurisdictions on some large-scale multi-jurisdictional projects, as well as the range of projects which will be funded by ANRO's in the open grants application process. Dr. Mayat Costello is the research manager at ANRO's, and I'm very happy to, you can contact her through our website. But if people want to, I can give my card to people if they want that, and they can go to the website from that, or give us a call. And if you have any questions about the research priorities and the research management system, or how we intend to go about that, I probably haven't gone into as much detail here as you might like. But if anyone's interested in hearing more about that, please do approach me. I'll be around at morning tea and later in the day, so please feel free to ask anything about that. But I guess I just want to emphasise again that this is an incredible opportunity that we have to have all Australian governments committed to a 12-year plan of action. That's a very coherent plan that is to be implemented across a set of 4 3-year action plans. Gives us the opportunity to reflect on what we've done, what we've achieved, and where we need to continue to go. But no one organisation can do this alone. We have a particular role in building evidence. I mentioned our stakeholders are policymakers, service providers and research community. There's another organisation, and I think Paul or Lara will be speaking in one of the concurrent sessions next about the Foundation to Prevent Violence Against Women and their Children. It's also an initiative under the National Plan, and it's focused on primary prevention, and its role is quite different to ours, and its stakeholders overlap, and our roles overlap. And in fact, we are working with them currently on a joint project to develop a primary prevention framework for Australia. That's also being done by, in partnership with Vic Health. So I'm going to leave it there now, because I do want to leave some time for any questions or discussion. But I just really hope that you can share in some of my enthusiasm for the national plan to reduce violence against women and their children, and do what you can to make a contribution, whether it's through your practice or research, or contribute to the research effort to build the evidence, so that we, in 40 years' time, aren't standing here saying, well, we've done a lot, but what really have we achieved? Thank you.